Tomorrow at 9, Oakland County Circuit Judge Kwame Rowe will announce his decision in the Miller hearing of the Oxford High School shooter. That shooter has pleaded guilty to 4 counts of first-degree murder, 1 count of terrorism causing death, and 19 other charges.
What's at stake in tomorrow's hearing is not whether the shooter will go to prison. That's going to happen, but whether he can be sentenced to life without the possibility of parole. He was 15 at the time of the shooting, and Miller hearings determine whether it's appropriate for a juvenile to receive the maximum sentence.
Attorney Sanford Jolman is here with us. He has experience in these Miller hearings. Thank you for joining us. This is something that we have especially been watching very closely, and we understand that the point of a Miller hearing is to try to give us a better idea of what goes into the mind of this young person as they face these serious charges. What are your thoughts on what we've seen so far and what's happening tomorrow?
Well, tomorrow's a monumental day, and it's worth following it, even if you haven't followed the entire process, because the judge is going to render his decision. And it's probably the most difficult aspect of being a judge, to rendering a decision as to someone's fate. It's not about whether he's innocent or guilty. It's about whether he should serve the rest of his natural life in prison. What makes this a little unusual is that when a defendant is convicted of first-degree murder, it's automatic. There's no discretion. But for a child, the judge has discretion. So the judge literally has the fate of this young man's life. And we're talking about not 20 years or 30 years, but for his entire life. And the alternative is a hearing that will determine whether the sentence should be between 25 and 40 on the minimum. A significant sentence as well, but not a mandatory life sentence.
Quite a bit of this case has been unusual, and you have argued in Miller hearings. You're very experienced with them. From the way the case started, with the shooter only being behind bars for months at this point, to even tomorrow with this hearing coming over Zoom, what stands out to you about what makes this case different?
Yeah, the Zoom is very unique, and I'm troubled by that a bit. I mean, it should be in an open courtroom. I don't know, maybe there's a protocol, maybe it's allow more people to view it, but for whatever reason, it just gives the appearance it's being the decisions are being rendered by Zoom. But I think that's less important. What's more intriguing for me is how the judge is going to address the most important factor, in my opinion, whether the shooter, whether the defendant has a likelihood of being rehabilitated. How is he going to explain that in his opinion? Either way, the severity of the offense is pretty clear, and it's horrendous, and it's repugnant. We know that is that going to outweigh the other factors? And how is the judge going to put this all together? He's been very quiet during this hearing. He has the right to ask his own questions, and he hasn't. He has a right to, ask follow-up inquiries or ask for additional information, and he hasn't. So now the judge gets to do all the talking, and it's going to be interesting to see what he says and applies those factors.
Yeah, we definitely want to hear from him. A lot of people went into this hearing very disgusted, very angry with that shooter, and some have come out still feeling that way, others almost feeling sympathy for him. Do you feel like that's how this was supposed to go?
Yes, and the Miller hearings I've done are when the defendants often have been in prison for decades. In fact, last week I had 2 defendants who were released after 30 years, and if you met them, and you saw their record, you would just know how different they are than they were when they were 15 or 16. And the judge doesn't have that. He just has this 15-year-old, and the audience, the viewers, just see this 15-year-old. And you're right, to sympathize with a shooter is not natural. We don't have that. But to sentence someone who is a child to mandatory life is unique in no other place on the planet except the United States, and Michigan is the #1 state that does that. So to do that is really a heavy sentence, and people do not feel sympathy for him, but try to understand both sides, and you don't really often want to do that and feel comfortable about doing it.
Now, as you mentioned, this is a very difficult, almost philosophical thing to prove, a very high burden for the prosecution. Based on what you've seen, do you think it could really go either way, or do you think it's looking like it's leaning one direction?
Yeah, I think it's leaning in one direction. I mean, you had the county prosecutor herself arguing this. That's unique. You have it on Zoom. That's unique. You have the severity of the offense. That's unique. The attention is unique. The youthfulness of the judge. He hasn't been a judge for that long. That's unique. There's a lot of unique factors in this, and much of it weighs against the defendant, in my opinion. I think that maybe many of us think that the law might change. There might be a retroactive change in the law, but I think the odds are not in this defendant's favor because really the severity, it's just so maybe insurmountable. But really, if you look at that one other factor, the likelihood of rehabilitation, I think if you stood back and you really want to look at it, it really should be a sentence somewhere between 25 and 40, because there really is no record of his inability to be rehabilitated. But the severity probably outweighs it all.
Absolutely.
Just to follow that up, even if Judge Rowe tomorrow says he is eligible for a life sentence without parole, does that necessarily mean he would be sentenced to that sentence?
If he says tomorrow that he is not eligible for a term sentence, meaning he will impose a mandatory life, sentencing will be a formality. It will be mandatory life for the rest of his natural life. There will be no hearing that will make anything really of any substance. It's really almost just a ceremonial type of thing. If he says that he's going to decide between 25 and 40 at the time of sentencing is going to be very, very important, and it's going to be very dramatic, and it's going to be very personal, and there's going to be a lot of discussion about it. It's far less important, well, that's not meaning it's not important, but far less important or significant if he does say tomorrow that he will not consider anything less than a mandatory life sentence.
Both sides have presented very strong arguments. Also, the first time we were able to hear from the shooter via recordings, and in those recordings we could see that this was very well thought out. He showed no mercy himself. He knew what he was doing. Based on everything that's been presented, what do you think we're going to hear tomorrow?
So those are the factors that really weigh against him so heavily. You know, if he was not a youth, it would be a mandatory life sentence. There would be no coverage, or it would be a pretty straightforward sentence. But I think that you're right. It's the severity of the offense that really puts the weight against the defense, and it's the only that whether the judge would say, listen, I have heard nothing that says he can't be rehabilitated. And really, that is the truth. I mean, there really hasn't been anything. In my experience, seeing them 30 or 40 years later, they have been rehabilitated. They're contributors, and they're completely different. But that courtroom, when we see it tomorrow, that 15-year-old will not be rehabilitated at the time, and the judge is going to have to justify, if he's going to give a mandatory life sentence, why he gave a child a mandatory life sentence without any real justification based on rehabilitation. Certainly there's justification based on the offense.
Yeah. Well, I don't envy the judge. This is a complex situation. Absolutely. We do really appreciate your expertise, though. You've joined us quite a few times throughout this process. A big day tomorrow. This is attorney Sanford Shulman. Thanks so much for joining us today. And we'll find about the sentencing later on this year in December.